Good morning and welcome to the Law Show. Bob Kerrigan with you this morning, and we're continue to talk about the various schemes and scams that defraud our senior citizens. We've talked about aspects of Medicare and all these supplements and advantage plans, etc., that are pitched at the time when you can sign up and supposed advantages of those. And then we've talked about the reality of giving up Medicare for a substitute insurance company that you really have no idea what they're going to insure and not insure. So I have taken a position, and I think it's not the position necessarily of, obviously, of the station or advertisers or anybody else, but my opinion is that there's real fraud going on, convincing people to give up something that they shouldn't give up, and in that case, Medicare itself. Now, we've also talked about various fundraising schemes that people come up with, and they call and say, for example, do you support our veterans? Well, yes. I mean, people would be unusual for a person to say no, they don't. And so they engage you in conversation. A lot of these start with robocalls, and then if you answer a couple of questions and you actually talk to a live person, they get paid based upon selling you whatever they're selling you. We talked about the percentage of your contribution that you make to the various organizations and how much of that goes to the fundraiser, the people raising money for the organization. The organization might say, well, hey, we don't care if we get some of the money. We're better off because we didn't have that money. So they really kind of look the other way, and the fundraisers decide, well, we're going to get in this and we're going to appeal to people's fear. These advertisements and these proposals across the board have a common denominator, and it's fear. So today I'm going to talk about the fear that the elderly have for dementia, for the development of dementia, and the multi-billion-dollar market of snake oil that's being sold to people ostensibly to enhance their memory when there's no scientific basis for it. So let me start, and I'm going to go through a lot of this. Today's program will be focused on Prevagen. You see all these advertisements for Prevagen, claiming that, well, they're cleverly done because they don't just out and out say, by golly, we can prove it, your memory's going to improve. I mean, everybody would just be flocking to stock up on this stuff. But that's not the case. These are things like people have anecdotally said, well, I've been taking Prevagen for 5 or 6 years, and I find my attention is much more focused on whatever. Well, you don't know if these people are loading up with every other kind of supplement that's out there. By the way, the Federal Drug Administration doesn't regulate these supplements. And invariably, they have disclaimers somewhere in their advertisements or whatever that these supplements are not guaranteed to do anything, but people take them. Now, for example, if you're deficient in vitamin D and you take a vitamin D supplement and your physician says that you should be to get your vitamin D level, that's entirely different from these general health food supplements. So let's talk about Prevagen. There was an article in the Journal of the American Medical Association, a very prestigious journal, entitled The Rise of Pseudomedicine for Dementia and Brain Health. Well, out of that article, they conclude that there aren't any benefits to any of these things that can be objectively and established and proved. Let me talk a little bit about testing and what these terms mean, okay? So you've got a product that you say is really going to improve a person's memory, and you want to test it. Well, the gold standard of testing is what they call a double-blind test, and here with a placebo. So here's how it works. You take a population of, say, 5,000 people, and 2,500 randomly selected, that's what they call randomized testing, randomly selected, they get the placebo, and the other 25 get the Prevagen, for example, or whatever the drug is that you're testing. if people administering it don't know which one they're giving. They don't know whether it's a placebo or whether it is the drug itself, like Prevagen, or the supplement like Prevagen. And the reason that's a superior method is that if you know which one it is as a physician or whatever, you might clue the person that's getting it that they're getting the real deal or they're getting a placebo. So when you have a double-blind test, the people giving it don't know, and the people receiving it don't know, and then they're tested later to see how that works. Now, there's some stratifications of randomized testing, breaking it down, say, to people over 50, people under 50, things like that. But that's generally how it works in randomized testing. So, first of all, Prevagen did a study themselves, a legitimate randomized double-blind test, and it proved that their supplement didn't help anybody. It didn't do what they said it was going to do. Those people that got it didn't perform any better than the people with the placebo. This article in the American Medical Association, the Journal of American Medical Association, was written by 3 prominent neurologists and dementia researchers at the University of California, San Diego. And they discussed this $3.2 billion that is made by selling these to people. And the reason there's a big market for it now is the increase. We live longer now, and that there is a greater incidence of Alzheimer's disease. Anybody that has dealt with a relative with Alzheimer's disease knows how tragic it is and how tough it is and how debilitating it is for not only the person that has it, but for the family dealing with it. So enter this outfit called Quincy Bioscience, and they're the maker of Prevagen, Prevagen, and they use a claim that they have scientific backing for what they claim Prevagen does. Well, the fact is they don't have scientific backing for it. And it says in this article that they lack essential features. Remember, I talked about the randomized double-blind testing of sufficient participant characterization, treatment randomization, and fail to include limitations. And these are published in what they call bad papers. Now, when they talk about a peer-reviewed article before it's published in one of these prestigious journals, other physicians have to look at it that are knowledgeable in the field. They have to test the premise, and they have to test the results, and they have to verify that, in their view, this is a valid scientific paper. No, this Quincy Bioscience didn't have that. They didn't have it at all. They cite to something called the Madison Memory Study. It's a study sponsored by them, performed by an employee of this company, Quincy Bioscience, and published in-house, meaning they publish it themselves, not publish it in a reputable journal or whatever. And in the world of real science, this type of study is ignored. I'm reading from an article from MedPage Today. I've talked about MedPage Today. I think it's excellent. The marketing, this article goes on, so the marketing for Prevagen is a clear-cut fraud from the label on the bottle to the ads airing across the country, said New York Attorney General Eric Schneiderman. The marketers of Prevagen have preyed on the fears of older consumers experiencing age-related memory loss, said Jessica Rich, director of the Federal Trade Commission's Bureau of Consumer Protection. But one critical thing these marketers forgot is that their claims need to be backed up by real scientific evidence. And it's not. So what happened? Well, there's a lawsuit that was filed. Enter the lawyers, what we do for a living. Okay, and there's fraud. Lawyers like to think that they're protecting society from it. I think they are in many cases. This was filed by the Federal Trade Commission and the people of the state of New York, and it was against Quincy Bioscience Holding Company, that company that I've told you about that makes Prevagen. Okay, so they filed this lawsuit. I'm going to just tell you some of the things they said in the lawsuit, and then I'll tell you what happened to the lawsuit. Okay. That Quincy actually conducted a randomized double-blind placebo-controlled study that contradicted their representations. The study showed no statistically significant improvement. So Quincy Bioscience did the study correctly, but it showed it didn't make any difference. The placebo people had just as good a memory or just as big a memory loss as the people who took the drug. Okay. The FTC has stated a plausible claim that Quincy's representations about Prevagen are contraindicated by the results of Quincy's clinical trial and are thus materially deceptive. Okay, so that was the lawsuit that was filed by the Federal Trade Commission. I'll tell you about that. So what happened to that lawsuit? It says that the FCT, by the way, the FTC alleges that Quincy's claim that the active ingredients in Prevagen, apoquarin, enters the human brain to supplement the proteins that are lost during the natural process of aging. That claim, this lawsuit says false. Well, where does this stuff come from? Okay, this is really funny, all right? If there is anything funny to all of this, it is that this stuff comes from a jellyfish's brain, and it's supposed to be beneficial to your brain. One of the problems is that jellyfish don't have a brain, okay, but it's supposed to be beneficial. As this one, I would just read some of the comments from the article that are made by just various people. And jellyfish have no brains, only neural networks. This is really a good one. Sea turtles must have great memories. They overload on jellyfish. One of the fewer that feed, of the few who enjoy fellowship, jellyfish as cuisine. Okay, so I'm just reading you some of the comments to the article, and I'll make another comment in a minute here. Old-time medicine shows go on and on. I can't figure out why jellyfish's extract will be good for anyone's brain. Jellyfish don't have brains. Several people knew that, which I actually didn't know. I should have known that, I suppose, from biology or something. Some course I failed to grasp that. And it's really helped my swimming, but I can't seem to remember how to get out of the pool. Okay. In order to get these products, they require you to sign up for automatic billing. All right. This stuff's like $30 to $50 a month. And invariably, the elderly are buying this to try to prevent this onset of dementia. And this summarizes it pretty good. Preying on the fears of an aging population. The common denominator we see over and over and over again. Preying on fears. Your identity is stolen every 31 seconds, according to the deceased Rush Limbaugh, as they were selling some program that prevents your identity from being stolen. Your house is going to be broken into. Your car is going to break down. If your car breaks down, you don't have insurance. You better get that insurance right away. Well, the judge that heard this case kicked it out. Kicked the FTC cases out, and that was appealed, and I read you a little bit from the appeal. So who is this judge? Lewis L. Stanton. Lewis L. Stanton entered this order that dismissed the case, bounced it out of court. Judge Stanton is 93 years old and on senior status, and the federal court allows elderly judges like this to participate if they're deemed to have their mental health and able to make good decisions. And I suspect that was, but it was just interesting to me that this case involved an elderly judge like this, and the subject of Prevagen was the subject of the lawsuit. Bob Kerrigan with you here on The Law Show. Thank you very much for watching us and for emailing and texting us, and stay tuned for more of The Law Show. Bob Kerrigan for Kerrigan, Estes, Rankin, McLeod, and Thompson. What is medical malpractice? In many ways, it's similar to an auto accident. If a driver of a car is careless and causes an accident and injures someone, the driver is responsible for those injuries. If a doctor or employees of a hospital violate the rules of medicine, they're responsible for the injuries they cause. These rules of medicine make up the standard of care that doctors and hospitals are required to follow. Medical malpractice cases are expensive to bring and can be very difficult. We're required to retain qualified medical experts to assist the jury in understanding why what was done violated this standard of care. At Kerrigan, Estes, Rankin, McLeod, and Thompson, we accept meritorious medical malpractice cases where substantial injuries or a death have been caused by a doctor or a hospital failing to abide by the rules of medicine. Please see our reviews on our website at kerrigan.com. Welcome to The Law Show. Welcome back to The Law Show. Bob Kerrigan with you this morning. We've had many text messages that we received during the program. We try to answer them all. We had a very nice couple from out of the state that moved to Florida to be with their grandkids and bought a new home, a fairly expensive home, and it was a disaster construction-wise. So we have coordinated them getting in touch with or connected to lawyers who specialize in this field. We do not. But our goal is to help people who contact us either by text messaging or otherwise to get them referred to somebody that can help them. And we have a number of other text messages that we received. We incorporate those messages and discuss the content of those messages and incorporate them in our planning for our program. I do have a personal note, however, that we received from a caller. I assume it was a man. It was hard to say from the text message. But this person suggested that one of the lawyers that appears here on the Law Show, I'm not going to mention any names of any lawyer, but that lawyer's hair and eyebrows need to be worked on. And in behalf of that lawyer, again, we're not going to name the lawyer, but I told responded to this text message that the lawyer was probably doing the best he could with the hand that he was dealt from birth. But in any event, I suggested that text messenger person send us a picture of himself so we could put that on the screen and then we could all judge that person by their appearance. I don't think that's the best way to judge someone, by their personal appearance, and I suggested that in my response to this particular text message that we received. Now, there's been a number of programs that we've done emphasizing how the elderly and in some cases uneducated people are abused and mistreated by the system or by the institutions that we have, like title loan companies and payday loans. We've talked about that in the past. Talked at length about the problems with reverse mortgages, that they prey on people who have spent their lifetime investing in their home, and they, in many cases, own their home completely free and clear. They want to draw some money out because their income needs to be supplemented, and so they are now on the target for the reverse mortgage lenders. They start off with big fees, $15,000 to set it up, interest rates, penalties, all kinds of things that are way more than you should have to pay. So we caution against reverse mortgages, and it wipes out the equity of your home if you plan to leave it to your kids or grandkids. It's a problem, I know, because people are hurting financially. But if you can avoid a reverse mortgage, please avoid it. We've talked about Medicare and these healthcare advantage plans. I call them healthcare disadvantage plans because they largely benefit the insurers only. You are getting an insurance policy from a private insurer that you have no idea what the terms and conditions of those are because they're complicated and it's all in the small print. And you're giving up Medicare. And in Medicare, people have worked, many cases, their entire life and have a government benefit of health insurance available to them from Medicare. And before you give that up for some fast-talking plans with a healthcare advantage salesperson where they're promising you eyeglasses or some other benefit, be very cautious, because if you get sick during that year, we've mentioned this before, you're going to be at great risk of being involved with a plan that has high deductibles in an area that you didn't even know you were going to need because you did not know what illness or disease that you were going to get during that year. So be very careful about that. And these supplement plans and all these other private pitch plans, get Medicare. Even if you have a Medicare Advantage plan, you still have to pay the at least $145 a month for Part B. So be very cautious about any of that. I've warned about these drug plans as well. It doesn't have to be this complicated. It has been made complicated so that the insurers can make more money. The more confused the consumer is, the greater the probability that insurers will be successful in selling whatever their products are. And speaking of products, I got very interested in a guy on TV. I'm sure you've seen it many times. He's on sometimes 10 times in a couple of hours. He's just on and on. And he's the My Pillow guy. And I thought, how in the world is this product so great that it's just come on the market and been made, I think, in Minnesota for a number of years, but the popularity of it was because of him. And so I looked into it a little bit, so I want to share that with you. There's some YouTubes out there about it, but here's the box. It came from Bed Bath & Beyond, and we've got a couple of other pillows, but this is called the patented adjustable fill. Well, I read the patent because I thought it was interesting. Well, what is it that's so interesting about, or so unique about the patent? And the patent, I don't know how the patent was granted, but the patent is this, that this thing consists of a number of pieces of busted up foam. I call it busted up. They call it particles of foam. They're not uniform at all. You know, they advertise that these are interlocking pieces in some complicated construction design, but that's not true at all. They're just pieces. So I'm going to take this scissor. I'm going to cut this open, and we're going to take a look at it and see what's inside. Now, there's a couple of YouTubes out there. This is not a unique thing by me, but I got very interested in it because they say the patent says there are 3 sizes: large, medium, and small. There's 100 on the patent that is demonstrated. They have 102 large pieces, 202 medium pieces, and 302 small pieces. As you can see, this is just a disaster. I mean, this is just chunks of foam falling all over the place. Look at this. There's just, and supposedly it bounces right back. Well, yeah, it bounces right back because it's foam. Okay, so that's the My Pillow guy. So you say, well, Kerrigan, why are you talking about My Pillow? Now, somebody might like this kind of pillow. Well, you can, if that's your thing, you can like it. But here's what I don't like about it. And here's what let me move this out of the way, by the way. I'm just going to make a mess wherever I put it. Here's what I don't like about it, and it's this box, okay? If you look at this guy on TV, and you see him on this box, obviously, and we're going to show you a picture close up of this, but he displays something on this box that has nothing to do with a pillow or anything else, but it has everything to do with religion. And so he displays on this box and in his picture and his TV ads a cross. Well, why does he do that? What is the point of displaying a Christian cross the way he's doing it? It's to sell pillows. That's the only reason he does it. If he wants to give a testimonial about his personal life, his conversion, or whatever his religious story is, that would be wonderful. He could do that. But to put his picture on the box, it's sending a message to people to exploit people who have a devout Christian faith. And they look at this, and he's hoping, when they look at it, that they will think he's telling the truth about the product that he's selling because he's wearing a cross. That doesn't make it truthful at all. In fact, as we've just demonstrated, and this is now a mess. I've got to hire somebody to clean us all up. Well, I said, Kerrigan, you clean it up yourself, which I probably will, actually. So it's all this junk. It's just junk, just pieces of chopped up foam, tiny, tiny pieces, big pieces, medium pieces. It's just a disaster. Maybe there's a decent cotton cover. I know, hey, maybe there's somebody out here that says, you know, Kerrigan, I actually like that pillow. Well, that's okay that you like the pillow. My point is this. It's the exploitation of people based upon their devout faith. And that it's wrong, in my view, to put that on a box. As I said, the only reason it's there is to try to send the message to people that they are particularly religious, or that he is. I don't know that. I can't judge them. That's a basic tenet of Christianity. You can't judge other people. I don't know what he is. I know this about him. He's a former addict, a crack addict of many years, alcoholic. He's failed in business. He's failed at other things. And he came up with the idea to make a pillow, which is great. He's making a pillow. And it may be comfortable. I have no idea. And here's another box. This is a Bed Bath & Beyond. This is a therapeutic memory foam pillow. I won't cut down one open, but I know it's solid. I can feel that it's solid. It's not these chunks of pieces. By the way, this stuff is all over the place here. In any event, what I find wrong about all of this is that people that use religion to sell their personal products or whatever they're pitching to make a profit, that's not an honorable thing to do, in my view. In fact, I have seen law firms where they advertise or they put in their materials that they put out that they're a Christian law firm. Well, that's fine, but that suggests to very religious people that they have a higher standard of ethics and honor. That may be true, but it may not be true at all. And if they have a very high standard of ethics and honor, why do they have to advertise that way? It's to send a message. I tried a case years ago against a lawyer that was unethical, on his best day, unethical. And he would try to send messages to the jury using particular biblical phrases that I knew and I was aware of. And I handled it. But some lawyers might try to send a message to a juror with this kind of secret coding, like talking about the other lawyer as a smooth talker and things like that, that would convey to deeply religious people of faith that this lawyer was one of them, when dishonestly, he's not one of them at all and never would be one of them to do that kind of thing in a trial. So be aware of that in terms of the marketplace. Religion is being used to sell everything from the prosperity gospel. If you send money in, that God is going to reward you if you give them money so they can buy a jet airplane and expensive clothes and jewelry and things that they want, which is not true at all, but it's designed again to appeal to people's faith. It's an exploitation of religious faith, which to me is just unconscionable. Unconscionable. Coupled with that, we have all of this solicitation by phone now, that if you are a veteran, you care about the veterans, then you should give them money, or you should give the police union money because they name themselves a benevolent fund, which they're not benevolent at all. They're a fundraiser for the union. Fraud, gross misrepresentation, dishonesty is pervasive in the marketplace. But our goal as lawyers is to communicate what we know about it to you, help you make better decisions, and to be truthful with it, and to ask for your help in sending us information that you think would be of benefit to our listeners. I'm Bob Kerrigan with Kerrigan, Estes, Rankin, McLeod, and Thompson. We're here every Sunday morning on The Law Show. Text us or communicate with us as any way you can by Kerrigan.com. I'm Bob Kerrigan. Have you seen the young lawyer advertising standing on top of a truck? I wonder who he would hire if he fell off the truck. Maybe the lawyer who has hundreds of billboards up and down the interstate. If it happened in Florida, though, it couldn't be him because he doesn't even have a Florida law license. He wouldn't hire the lawyer who barely has time to eat with his family because he just seems too busy. Maybe the lawyer who busts down his office wall, but that may not be a good place to be if another wall is crashed through. If he called us, we'd tell him it wasn't the brightest idea to climb up on top of the truck in the first place. With the highest ethical and legal ability rating from Martindale-Hubbell. We represent one client at a time, and we've represented thousands of clients over the years. Your case will be handled by a board-certified partner, board-certified in civil trial by the Florida Bar. Kerrigan, Estes, Rankin, McLeod, and Thompson at Kerrigan.com.
Welcome back. This is The Law Show. It's sponsored every week at this time by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our law firm specializes in cases that involve serious accidental injury and wrongful death cases. And those are cases where loved ones, people are killed in serious accidents. Our firm has practiced across Northwest Florida for 40 years. And during those 40 years, we have opted to focus almost entirely on accidental injury cases. We are trial lawyers. We are board certified in civil trial law, and that is a type of board certification recognized by the Florida Bar for lawyers that do this sort of personal injury practice. And we're proud to host the Law Show every week at this time, where we hope we provide helpful information about topics that we deal with week in and week out, and we answer questions that you present to us. And in this kind of modern age, we can do it by text. And so our main number across Northwest Florida, across the Panhandle, is 850-444-4444. And you can text us this morning at that number, 850, and then it's all fours, if you have a comment or a question about the show today. You can also email me directly at my email address, which is mike.mcleod@kerrigan.com. So email us or text us if you have a question or comment about today's show. And so I want to talk about a somewhat new a resource that we can use when we investigate serious automobile accidents. So traditionally, and we still use these methods, of course, when we're hired by someone who's injured in an accident, we will immediately want to investigate and document how the accident happened. And we do that through traditional means. Our investigators look for witnesses, and witnesses can come from people in other automobiles who see the accident. They can come from passengers in one or more of the vehicles that are involved in the accident. In today's world, people at businesses, bystanders, sometimes see accidents and can testify about who ran the light, who was at fault, how fast were certain vehicles going at the time of the accident. And those are somewhat traditional ways that for years and years we have investigated and put together exactly how accidents occur. Another thing that is somewhat more traditional than what I want to talk about in just a few minutes are using knowledgeable experts, engineers who have special training and experience in helping us recreate accidents. And some of the simpler things that they do are things like they can measure the coefficient of friction of certain asphalt roadways to see how much they grip tires when they brake, and they come up with a calculation for that. They can measure skid marks from tires that are left on the road after a vehicle puts on their brakes hard and skids to a stop, and they can use formulas to try and determine, well, how fast was this car going, depending on the length of the skid mark, how hard the braking was, the coefficient of friction of the asphalt roadways. Also, some experts can examine, for example, seat belts to see whether or not there's a certain tension on the belt and give an opinion about whether or not the occupant of that seat in the automobile was wearing their seat belt. But today, in today's world, we also have this terrific resource, and that is called an electronic data recorder. And so automobiles, really since the year 2000, most of them not all of them, but most of them have an electronic data recorder embedded into the center of the automobile. Typically, it's under the front seat or between the two front seats. And it's underneath, I guess you'd call that center console. And the electronic data recorder, sometimes we call it the black box of the automobile, was originally introduced by General Motors. And so ever since maybe it's 2010, I would say almost 100% of automobiles in America have electronic data recorders on all of these vehicles. And so we can extract the information that these black boxes, and they're really very similar. They're not as sophisticated as an airplane black box. When an airplane crashes, technicians can retrieve the black box of an airplane and recover all sorts of data. Well, in today's computer world, we can do almost the same thing with your automobile, with all automobiles that are in serious collisions. It's required now that technicians with sufficient training to extract the information from the black box, the electronic data recorder after an accident. Florida Highway Patrol officers, some of them have the capability of extracting this information, and they do in serious accidents when they are not sure exactly how an accident happens. So they can extract this information from the black box after a serious accident, and then on a computer they can read all sorts of information and data about how the accident happened. For example, the black box recorder will tell us exactly the speed of this particular vehicle at the time of the collision. And we don't have to rely on eyewitnesses who are sometimes wrong about the speed or their estimates about the speed. Over the years, we hear people say, well, I think they were going the speed limit. I think they were going over the speed limit. I don't know exactly how much, or this car was going really fast. And those are helpful, but the black box information will tell us the exact speed a vehicle was going at the point of impact. It will also tell us the percentage of acceleration on the accelerator pedal at the time of an accident. For example, a computer printout will tell us that 5 seconds before the accident, the accelerator was pressed at 50%. It'll tell us the RPMs of a vehicle. We had a horrible accident that we were involved in investigating with really severe and dire consequences for the occupants, that we were able to obtain this information, and we found that the driver of the at-fault vehicle, who was driving through municipal streets, not out on a highway, but in an in-town area, had the accelerator pedal pressed all the way to the floor well before the collision, well before the impact with a telephone pole, all the way up to the impact with a telephone pole. And we knew precisely that the pedal was pressed all the way to the floor, 100% acceleration. And the speed and recklessness of that driver is no doubt what caused that severe accident. The electronic data recorder will also tell us the direction of impact of the crash. Is it a head-on collision? Is it a side impact? Is it an angular impact? It'll tell us the precise direction of the force of the other vehicle or the other thing that the car impacted. In a rollover accident, the electronic data recorder will tell us the angle of the rollover. I'm checking my notes here because there's so many things that the recorders will tell us after an accident. And this can be very important. The data recorder can also tell us which of the front seat occupants were wearing their seat belts. It'll be recorded on the recorder. And why is this important? In Florida, if you're injured in an accident in your automobile and you were not wearing your seatbelt, a jury can put fault on you for contributing to your own injuries. We know that seatbelts save lives. We know that seatbelts limit injuries. And so juries and insurance representatives can penalize, as far as recovery for the injured person, those plaintiffs, those people that are injured, for not wearing a seatbelt. Florida is what we call a comparative negligence state. And that means that when we analyze who's at fault in an accident, or when juries assess fault in an accident, juries don't have to find one party 100% at fault and the other not at fault at all. They can compare fault. It's done in almost every trial. And so even though another vehicle runs a red light and hits you and injures you, if you don't have your seatbelt on in Florida, as you're required to have, a jury can put some fault on you for your own injuries, even though the other person was at fault in causing the accident. So the electronic data recorder can tell us whether or not either of the front seat passengers were wearing the seatbelt. It can also tell us the angle of the steering wheel. All of these things can be critically important in determining a complicated accident, and whether or not our client was completely without fault, who was at fault. All of these things are accessible now from investigators that are trained and authorized to download this sort of information. So in today's world, we very quickly, after we're hired in an accident, when somebody's been injured in an accident, we want our investigators to do the traditional types of things that we've done for many, many years. Look for witnesses, look at businesses and storefronts to see if there's some video running, 24-hour surveillance video. In many of our cases, we've been able to find store videos from cameras that run 24 hours a day, and we've been able to obtain video of the accident itself. Not so uncommon in today's world, where you can just present your client's case with an actual video of the accident, which sometimes shows who's got the light. Not uncommon at all, but it takes some footwork early in the case before things get erased and people forget what they saw. And then the second thing in serious accidents we can do is get all of this specific information from electronic data recorders that will tell us without any question exactly a lot of these details about accidents. We're out of time for this segment of the show. I'm Mike McLeod. It's our pleasure to host the Law Show every week at this time. All of the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson. And we'll be back in just a minute with more of the show. Thanks for watching. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida.
Welcome back to the Law Show. brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I am Randy Thompson. I am the last name partner in the group. And so you got the bottom of the barrel to talk to you this segment, but I want to talk to you about negligence, specifically in the area of trip and falls and slip and falls, or what lawyers know as premises liability claims. A property owner, whether you're a private individual or a business owner of a commercial real estate adventure, a superstore, grocery store, any business that invites the public in, you have an obligation to maintain the property in a reasonably safe condition. Doesn't have to be perfect, but it's got to be reasonably safe. And you as the owner have to look for, be aware of dangerous, hidden conditions on a property that could cause someone to trip or get injured. And it's your responsibility as the property owner to go around on a reasonable basis every hour, every 2 hours, and look throughout the property for areas that may cause a hazard to people who are invited on your property. So I want to give you an example now, and we'll put up a still photograph of a pallet of firewood that's sitting on one of our local grocery store's sidewalks. I represent a client who ended up being injured at this property. And so I want to talk to you a little bit about looking at that photograph, understanding what that photograph shows, and then we have a different view of that same area. This was taken by the store management after my client got injured. And so in looking at those photographs, do you think there's a negligent condition on the property? Do you think there's an unreasonable hazard there that may cause someone to get injured? My answer would be yes, I do. And although I'm concerned about that crumpled edge of the sidewalk there that you can see, because clearly the store knows it's broken. Clearly the store knows it's not level. Clearly the store, in my opinion, should know that that could cause a tripping hazard, especially to an older person who may not see as well. But in this particular case, it's that row of plastic, that string of plastic that's left hanging off of the pallets and blowing in the wind. Obviously, you can't see it blowing in the wind on these still photographs, but we have videos and the plastic is blowing around. And it's clearly, in my opinion, a trip hazard. What do you all think? Do you think that's a negligent condition on the property? Do you think that's an unsafe condition on the property that may cause someone to get tangled up and hurt? Even if that answer is yes, that's a negligent condition, we still have to prove who caused the condition. How did it get there? The law in the state of Florida says that if the property owner placed it there, then they should be aware of it and they have constructive knowledge of the condition. We took the deposition of the management of the store, and they, in fact, said, yes, we put it out there. We directed that that pallet and that plastic covering that firewood be out there. And so from a standpoint of how did it get there, who caused it, we think that's pretty clear. The management of the store caused it. But then there's another question. Because just because the management of the store placed that pallet there with that plastic on it, maybe the plastic was all contained at the time and it was tight around the firewood and it wasn't blowing in the wind and potentially reaching out to grab someone. So maybe the management of the store gets to say, but it wasn't a negligent condition when we put it out there. We didn't know. We didn't see any of the stuff blowing around in the wind. Well, watch this videotape. It won't take you very long. It's about a minute long, I think. That young man in the black works for the store. That young man is their employee. That young man walks by this blowing plastic probably 4 times. He had to come out right past it. He went right back in to the doors. He came back a 3rd time. Coming back the 3rd time, it looks like he's perhaps looking at trash on the ground, that piece of paper, but he doesn't do anything to pick it up. He doesn't do anything to make the property reasonably safe. He just keeps on walking. So, do I think that the store knew or should have known that a dangerous condition existed on their property? My answer is yes to that. I think they knew because when they set those pallets out there and they left them knowing that people in December would be using firewood, and they knew that that plastic would continue to get looser and looser. And despite that, they left it there. I want to show you a couple of still photos of someone who is not my client. This person, or these 2 men actually, that you see in this photograph, get tangled up in the plastic. And they get tangled up in the plastic about 30 minutes or so before my client, who ultimately comes along and gets caught in it. The store management wants to say, oh, well, those 2 men, they're the ones you should file your complaint against. They're the ones that caused this problem. That's not true. That plastic was out there blowing around, and these 2 gentlemen happened to get caught up in it, but they didn't fall. They didn't get injured. They just drove off. Well, what do you think if the store says, well, blame those men? They should have been down there. They should have picked that up. They should have called us and told us. It's not your obligation as a customer to walk around a store and tell the store what to do and how to be safe. So when you have a store and when you have employees who don't act reasonably, who don't take reasonable precautions to help and protect their customers, well, here's what happens. In this video, you will see my client and her husband coming out of the store, and at the very edge of the clip, at the very end of it, you see my client fall down. Ultimately, she had to have a complete total shoulder replacement because of the fall. Those are the damages that can happen, not to everyone. It didn't happen to the 2 gentlemen who also got tripped up in it. It didn't happen to the 10 or so other people who walked right over it and didn't get caught in it. But it did happen to my client. But now the store wants to say, oh, well, the fall is all your client's fault, Mr. Thompson. Your client is the only one that got tripped up in it that we know of. Your client is the only one that claims she didn't see it and she got hurt by it. So it's your client's fault, Mr. Thompson. So that's kind of the overview of how premises liability cases in Florida oftentimes play out. Sometimes the store management will say, oh, it was our fault. We agree. We acknowledge. We should have done better, but let's blame the injured person. The significance of blaming the injured person is that if the store convinces jurors that, let's say the fall was 50% my client's fault and 50% the store's fault, if the store convinces the jury that, well, it's all 50% her fault, then my client only recovers half of her damages. And her damages include the medical bills caused by the fall, the medical surgery, the anesthesia bills, the rehabilitation bills. My client was retired, but if she was unable to work, it would include her lost wages. But remember, if the store convinces the jury that it's 50% her fault, she only gets half of her lost wages. She only gets half of her unpaid medical bills. And that applies as well as to future damages. If she has to have future surgeries to remove certain hardware from her shoulder, or if she has to miss more time from work or attend more physical therapy. So the percentage of fault, the issue of comparative fault, is very significant. And if you are lucky enough to serve on a jury, and I do mean that, if you're lucky enough to serve on a jury and you're in a comparative negligence issue, lawyers will talk to you about that and they'll explain the significance of it. But it has real effects on a person's life. It has real effects on the store's pocketbook, right? Because if 100% of this fault is theirs, then the store owes all of the related medical expenses and lost wages. A jury could decide it's 90% the store's fault and 10% my client's fault. 95% the store's fault, 5% mine. They could decide that it's my client's complete fault, all on her own. I would think that would be an unfair verdict, but they could do it. It all depends on how the evidence comes out and who testifies, how they testify, the demeanor they have while testifying. And so all of those pieces of evidence come before a jury, and ultimately the jury is asked to decide, was the store negligent? What do you all think? I think yes. Did the store know about the condition? I think yes. Did the store leave it there for a long enough period of time that they should have known about it? I think yes. Was my client comparatively at fault? I say no. It's clear plastic blowing in the wind. She was walking with her husband, holding on to the cart. Those are things for y'all to think about the next time you go onto somebody's property and start looking around. Again, I'm Randy Thompson. I'm one of the partners at the Kerrigan, Rankin, McLeod, and Thompson law firm. We are always glad to talk to you about your claims and your injuries. Sometimes we can't do anything to help you other than tell you what the law is and tell you how it applies in your case. But we're always glad to talk to you. So feel free to call us. Look us up on the web at Kerrigan.com. And we'll be back again next Sunday.